I believe the state is here represented by Ms. Looney. Mr.
Right, Your Honor.
Antonesto, I believe you're present representing the presumed father at this point.
Correct.
Okay. And then we do have the guardian there. Do I have anyone else present on this case? Does not appear so. Okay. Let me just jump into the digital file. When we were last here, I believe, I know you all still, at least according to my records, have a trial date set in February. And I believe, based on my notes, we set this as a review regarding potential DNA testing. But I'll turn it over to the parties and get their input.
Your Honor, I may be able to help with that piece. We do have an active parentage case open here with the prosecutor's office. So we are actively moving towards getting genetic testing ordered so we can move forward with determining if Mr. McKnight is the biological father of the child.
And my client remains, he's in jail in Wahkiakum County, and he's willing to submit to the DNA testing and actually wants to have that issue resolved.
Okay. So is there anything the parties are requesting of the court today? Again, I see that the trial on the underlying petition is set and the previous order of the court appointing emergency minor guardian is good through the hearing on the full petition. So let me know if I'm missing something that needs to be done today.
I think the only thing I need to know is when we can expect to have the DNA testing done.
We are still waiting on confirmation of service on Mr. McKnight, and we'll be moving forward once we're able to have that completed.
Okay. Yeah, he can be served through the sheriff's office in jail, Wahkiakum County.
Okay.
Thank you, Mr. Agos. We were under the belief he was in a different facility, so I'll make sure we update that.
Okay. Do the parties want a review date on this case for this issue, or what is your preference?
I would prefer a review date so that we're not, right before trial trying to get this resolved.
Okay. So let's see. You want to do about another 30 days?
That's fine with me, yeah.
Okay. Would the parties be available December 2nd at 10:30?
Yes.
Or sorry, I said December 2nd, and what I meant was December 12th.
Yeah, I was gonna say that's a Saturday.
Yeah, don't come in on a Saturday.
The 12th is fine with me, Your Honor.
Okay,
That's your for state as well.
Okay, we'll set this for December 12th, 2023 at 10:30 a.m. Ms. Hicks, thank you for being here. There's not much or anything that you need to do. Do you have any questions for the court?
No.
I believe as far as on this matter,
Thanks.
and I believe I saw the guardian on as well.
Amy Powers for the state of Washington.
Thank you, Ms. Powers.
And John Sasaki, counsel for the father, Jeremy Layton, also present.
Thank you. I'm just looking through my Zoom screen. Is the guardian here? Yes, I believe you're there. Are you able to unmute? Okay, let's skip this one. We'll come back to it just as soon as I see her maybe come on screen here if she's working out a tech issue. 08, I have Ms. Day on that matter. I believe Ms. Booth is present.
Yes, Your Honor, I'm here.
We have Jessa Booth with us. I'm just striking out this morning.
I will text her. Let's come back to that one. I'll text
Okay.
her and see if we can figure out where she's at. Thank you, Your Honor.
Perfect, thanks. Let's go back to number 2. I see, Ms. Kononi, you have figured out your camera. Can you hear the court?
Yeah, I can.
Okay.
Sorry.
Okay. Then, Mr. Sasaki, it looks like we are ready to call this matter if you can still hear us.
I can, thank you.
Okay. So when we were last together, my concern, and I'll probably sound like a broken record today, but was just a lack, two things I think we talked about last time, a lack of DCYF records. And the clerk was going to be resubmitting that through the new or old, whatever portal that I guess seemed to have been the hang up here with some records. I don't have those. I don't know if any other party has received those, but I have not received any response from DCYF. And then I think we also had started potentially to talk about visitation while all of this is pending, but didn't make a ruling on that last time. So let me turn it over, I guess, first to you, Ms. Farr, and then I'll go to Mr. Sasaki and then to the Guardian.
Your Honor, I believe you're correct that we don't have DCYF orders. I don't recall that we started talking about visitation, so I will wait to tell Mr. Sasaki and speaks to address that.
Okay. Mr. Sasaki, go ahead.
I haven't received any records from DCYF either. And no, my client hasn't commented on visitation, and it didn't appear that we had addressed that. And so I was curious if the Guardian petitioner had any proposal in that area that I might be able to run by our client.
Okay. Yeah, I just had put in my notes that we talked potentially about child support and visitation. And then I believe we were going to set that over maybe for a further look at.
So, Your Honor, father is incarcerated and mother is homeless and hasn't had much contact with the child or the guardian.
Okay, so no, obviously no visitation. Nothing to address today anyway, I guess is what you're saying.
Yes.
Okay. Ms. Kuanoni, I'll explain the first thing we're looking for. The DCYF orders, it's not, you've probably been on docket with me and heard my frustration with this process, but it's essentially a document that our court emails over to DCYF and asks for any history of founded or open investigations involving your household. We found out about a month ago that there's a new email address they want those requests sent to. We've been doing that. We've had some success in some cases getting those pretty quickly. But on my cases today, including yours, I do not have that response. In order to move forward with further orders in this case and any sort of finality for the parties, we have to have those orders first. So it would be an automatic set over of this case for that reason. But then do you have any input on the second thing we talked about at our last hearing, which was child support requests or visitation?
I think the child support was already set because I think both parents did receive something about what their child support is going towards anyway to CSHS. I'm not really sure. I just know that mom says that she has to pay $500 a month because she never responded when she got the information. And I don't know what dad paid, what he has to pay. Like I said, he's incarcerated. I've seen mom probably 8 times in the last almost 2 years. So she, will once in a while call me, or actually text me and ask or tell me I'm going to call, and I don't ever get a call. But I do talk to dad fairly often. I text him back and forth with pictures and whatnot. So I don't know what because she gets the support from DSHS, Canada. And so they've got it set up that they pay them.
Okay. Okay, so sounds like, if I'm not mistaken, there's really nothing for us to do today except except set another review date to see if we have those DCYF records so we could move forward on an emergency guardian order versus just this immediate order. Does that sound correct to the parties?
Your Honor, I believe
Yeah.
we're getting ready to enter the final orders because we have consents from both parents.
Okay.
And Your Honor, we are still asking that the court enter a child support order. Even if there has been an administrative order, we're requesting that support from the father be $50 a month, and it will be abated down to the $10 a month since he's incarcerated. We put the mother at minimum wage, but we left the deviation section in. Based on the pleadings, it appears that there may be some substance abuse or housing issues that might impede the mother's ability to work. So if the court felt it was appropriate to deviate downward based on those things, we've left it into the order for the court to do that. I don't know whether the court would be willing to just enter the child support today, or if we need to wait until you're finalizing the whole action.
Yeah, do you have those orders? I would be happy to address it, except I didn't have any in my file, so I'm just checking with the clerk.
It looks like these are the child support.
Mr. Sasaki, is this something that you have reviewed on behalf of your client or would be reviewing on behalf of your client?
Yeah, I was aware that the income had been abated due to his incarceration for another 3 years. However, I noted that it was set at $50. I did not note $10 in any of the pleadings, but if it has been abated due to the circumstances, then there shouldn't be any objection to that.
Okay. I guess my question would be, has Miss Bornstedt, have we attempted to serve her with this proposed order?
It was sent to her April 6th when we entered our notice of appearance. We also sent the proposed child support order and worksheets at that time. And like I said, our proposed order leaves the deviation section in.
And Ms. Farr, do you want to give any input on child support in this case?
I usually don't
Okay.
have any input.
I'm just give me just a second to go back to April, since I was not involved in these dockets back then. And then Ms. Kuanoni, what was the input you had about Ms. Bornstedt's current kind of living status, working status, if anything?
She was incarcerated she was incarcerated again last week, that I understand. And I don't know if she stays someplace. She has a boyfriend that she stays with. But I don't, sometimes they stay with different people, I think, because they don't have a residence, or they stay in their cars, or, things like that.
Okay. Here's what I'm inclined to do, since we're going to set this over for the DCYF records. I mean, I think clearly father's income is set appropriately, or obligation, is set appropriately, because his expected release date is not until 2026. So we're not anticipating a change since April. Ms. Powers, would your office be willing just to do a little digging between now and our next court date into whether there's, I don't know if there's wage reports since April of 2023 on the mother that would shed any light on this. And then maybe Ms. Kuanoni, if you want, you certainly could reach out to Ms. Powers with any input you have on that. I guess I'd just like to know if there's anything with mother since April of 2023 that would be more or less a required change to the imputation at minimum wage.
Yeah, she hasn't worked at all. I know she hasn't worked at all.
Okay.
Would the court like me to file something in writing about that, or can I report verbally at our next hearing?
Yeah, verbally's fine.
Okay.
As an officer of the court, I'm more than happy to take your word on what you might find between now and then.
Okay, I will see what I can find.
Okay, I appreciate that. And then what would be the next date we would want to set in the hopes that we could be finalizing orders at that time? Do we want to also look at December 12th, or do folks want to go a little bit further than that?
Yeah, Your Honor, I have a trial on December 12th in Clark County.
Okay. What about December 19?
That would be fine with me.
That works for me as well. Does the court need us to send over some new original orders and worksheets?
No, unless you're going to change, well, I can also interlineate. We do have the clerk has the originals from April, so we're fine there.
Okay, great.
The 19th would work
Okay.
for me as well. If I just may request some clarification on the orders with regard to visitation, because that has been left blank on the petition for guardianship. And if the petitioner guardian can specify what that visitation might look like, I can inform my client and make any necessary objections accordingly.
So, Ms. Kuinoni, between now and December 19th, you could either file with the court or reach out to Ms. Farr with kind of what your recommendation for any visitation specifically with father would be. I mean, address mother too, but Mr. Sasaki's request is, what is your anticipated or expected visitation with dad? Moving when we present this as final orders. Right now we're still in temporary status, but once it's final, what would you like visitation to look like? What are you comfortable? Obviously, I know that could be, phone visitation with dad right now. I don't know if you intend to take child to see him, those types of things.
Mm-hmm.
Okay.
I don't know. And I don't think he really wants me to bring her there.
Okay. And maybe Mr. Sasaki, if you want to ask your client what his requested visitation might be, that will be helpful for our final hearing too.
Yes, Your Honor, I will do so.
Okay. Okay. All right, we'll see you back on December 19th. I will just make sure that our immediate order extends through that date, and I am optimistic we will have the DCYF records and be able to finalize this before the end of the year.
Thank you, Your Honor.
All right, thank you all. Junior,
Thank you very much.
Yeah, thank you. You are free to log out. I do believe we have Ms. Redden online. We have Ms. Muldoon. Ms. Farr is on this matter as well. And do we have Mr. Gooday? Oh, I'm sorry.
Your Honor, I'm here.
It's Ms. Day, not Ms. Farr. I think I'm sorry, Mr. Gooday. Did you say you were here?
Yes, Your Honor.
Okay. So when we were together last, this was 11/7. There is a continuing request for visitation. We're still in the immediate emergency guardianship order stage. Has a full petition been filed in this one yet? Ms. Redden, have you just filed the emergency, no full petition?
Just emergency right now.
Okay. So I know we have visitation hanging out there. Ms. Day, let me first turn to you, and then Mr. Gooday, I'll come to you.
Okay. Thank you, Your Honor. I have had a chance to meet with the petitioner and mom, and I've been able to do some preliminary investigation. Mom is actively involved in treatment and making good progress. I've been to her home. I didn't find any safety concerns there. I know that Austin is struggling somewhat with kind of the circumstances of the guardianship and just the nature of how this has unfolded. But I do think visitation is appropriate, and I don't see any reason that we couldn't at least begin some type of in-person visitation. That would also allow me the opportunity to observe Austin with his mother, see that she's able to manage his behaviors and those kinds of things. But he is starting some educational things due to some deficits he has or deficiencies he has. So that will be with the Woodland School District, and that needs to be the priority. But I don't see why we couldn't accommodate some type of contact in person.
And Ms. Muldoon, where are you living now? I know there was some.
I
Go
live
ahead.
at my grandma's in here in Clark County, off St. John's area. So I am in Clark County, and I know my son does school in Cowlitz, because that's where Cassandra and them are living. Eventually, I do want, what I am going to do is, no matter what, I want to keep him in this school year to let him finish it out. But hopefully by next year he can transfer somewhere closer to where I'm at. If I get him home by then, it's just one day at a time type thing. But I do want him to stay in the school district he's in to finish it out.
Okay, let me ask Mr. Gooday first. Are you today, well, Ms. Day, some input too. At some point, we need to have kind of the show cause hearing on the order for emergency guardian. I don't know if we're there yet today, if we need more time for that. I also don't see DCYF records on this case. So is it the party's preference to go forward with that show cause today, set that for a different date, and deal with visitation today on the immediate order?
I think we could just deal with visitation today, Your Honor. From what I understand is Miss Muldoon's mom or grandma will be filing guardianship as well. Is that correct?
Yeah.
So that's
Okay.
a possibility if that's happening as well. So I was kind of wanting to see what Miss Day's report was going to say about everything.
Okay.
That's what we were waiting on as well, Your Honor.
Okay.
So, Your Honor, I do think it makes good sense then to set this for show cause. It certainly doesn't need to be done today, but I do think that we shouldn't belabor that point from the legal standing of everybody's rights involved in this, including Austin's. If there is a need for a guardianship, then the court would then need to make the decision about whether or not to continue with Ms. Redden, or if the relative has come forward that mother is choosing, then that would be the time to make that decision as well.
Mm-hmm. Ms. Redden, what's your input? I think it seems like where we may be leaning today is addressing visitation under an immediate order, and then setting a date for not lengthy, but a lengthier kind of show cause hearing where you certainly could give testimony to the court about requesting the emergency order. Those orders, the court has distinct timelines. We can issue them for 60 days, and then we can reissue for another 60 days. But unless a full petition gets filed in that time frame, the court's really hamstrung on. It's not like these where I can just kind of re-up the immediate orders as I see fit. There really is statutory deadlines for once we get into the emergency order.
Okay. No, I think Brianna has been, from what I understand, doing well with her treatments and stuff. And me filing these weren't to keep Austin from her. It was more for her to realize what situation she was putting him in. With her living with her grandma, I feel like it is safe for Austin to go over there. Maybe one day on the weekend so that he can start seeing her, because I know he does want to. And then that way he can still continue with his schooling and treatments that we are in play for setting up.
We have two now.
We have two different ones.
Okay. No, I think you guys are all doing a great job working together for the benefit of Austin. So I appreciate that. I am inclined, because I know how hard Ms. Muldoon has been working, and Ms. Redden has supported. I am inclined to grant in-person visitation. It sounds like starting out with a day on the weekend would work best for everyone. I'm thinking Saturday because that unless schedules conflict, because then Austin can be back in Cowlitz County on Sunday to kind of decompress and get ready for school. Would Saturday work for the parties?
That works for me, Your Honor.
Yes, Your Honor.
Your Honor, I would ask that the court include restrictions that obviously no substance use or non-prescribed substances, but also that the great grandma be present at least for the initial few visits. I think that she's agreeable to that. I believe Brianna's agreeable to that. I think that helps provide extra support for Austin, and maybe start out with four hours and then increase after a couple of visits. So it allows him a time to adjust.
Okay. Ms. Muldoon, is it your mother or your grandmother?
It's my grandmother.
So his great grandmother.
Yeah.
Okay. So Minor's great grandmother present during visits initially. Does that work for you and for her, Ms. Muldoon?
Yeah.
Okay.
Yeah, she's home every weekend.
Okay. And then time frame. Well, let's first talk logistics of getting Austin coordinating the transportation. How is that going to best work for Ms. Redden and Ms. Muldoon?
Either way, my grandma will be the one to drive if we need to pick him up, or if they want to meet. Grandma will be the one driving to get him either from them or vice versa. They could always bring him to grandma's, either or.
Okay. Ms. Redden, I know you all have a lot on your plate. What works for you?
We can go 50-50. I mean, I'm willing to drive him there and drop him off if they're willing to drive here and drop him off.
Okay.
I think that'd be a great compromise. Will that work for you all, Ms. Muldoon?
Yeah.
Okay. So drop off will be with the Reddens, and then Ms. Muldoon, you and your grandmother will do the return.
Yes.
Okay. And then let's talk hours on Saturday. What is convenient, Ms. Redden, for you for drop-off time?
Austin is an early bird, so I would say 11 or 10, somewhere around there, so that way he gets back and we can get him dinner and start his nighttime routine, because he's usually, during the week, we try to start getting him ready 7:30 and try to have him in bed by 8. So weekends we give a little bit more leeway, like a half an hour or so.
Could we do drop off at 10 a.m. and then return back about 3:30?
That works for me.
Would that work okay?
Yes. That works.
Okay.
Yes, Your Honor.
Because then I'm figuring you kind of leave your house in Clark County by 3.
Yeah, you can get him home about 3:30.
Okay. Let's do that. And then I'd like to see how this visitation plays out for a few weeks before we do the show cause hearing. So would folks be okay with doing this visitation for 30 days? So hopefully we have kind of 4 visits in there before we come back and talk about the order on emergency guardian.
Yes,
I think that makes good sense.
Okay. So if I could give you that, let me make sure there's enough weekends in there. 1, 2, 3, 4. Yeah, if we could do December 12th, that'll give us 4 Saturdays.
I just want to let Your Honor, on November, I believe November 30th, I believe it's a Friday.
Okay.
Austin does have a dentist appointment. We had to cancel his last one because he started getting sick, so we weren't able to have his teeth work done. So that Saturday, he is probably going to be a little cranky.
It's a Thursday, just so you know, Miss Redden.
But
he still probably will be a little cranky on Saturday.
Yeah, well, I'm on my phone, so I can't look at my calendar, but I know it's at the end of the month. So I just wanted to let everybody know that he does have a dentist appointment. They are putting him under to do some work, and he's probably not going to be a happy camper.
Okay. Well, and what I would say on that, I don't think I need to put this in a formal order, but I certainly can. Ms. Muldoon, just stay in contact with Ms. Redden on that Saturday visit.
Okay.
I would be fine if, you know, on that one weekend, Sunday ends up working better for the parties than Saturday, you know, work together. If for some reason there is obviously a greater than normal reaction to this type of oral treatment, then if we, you know, skip that visitation, I'm not going to find, you know, you, Ms. Redden, in any sort of trouble because you kept him home that weekend to recover. I fully understand that.
Okay. And I'll definitely, let Bree know how it goes and each day how he's doing and how he's feeling or, how he's acting.
Okay. Anything else we need on this case? And Mr. Gooday, does December 12th work for you? I anticipate, absent things happening between now and then, that we would go ahead and do the show cause hearing on the order for emergency guardian on that date.
Yeah, I'm available on the 12th, Your Honor. Thank you for asking.
Okay. All right. Anything else on that matter? Otherwise, I will do a new immediate order. The difference you all will see is that it will include a provision adding the Saturday in-person visitation that we discussed.
Thank you, Your Honor.
Okay. Thank you all again for working together. And
Thank
I'm
you.
just pulling up my digital file again. This is a case where there is, as I understand it, the full petition has been filed. So the order on emergency guardianship is good through the date of whatever hearing will happen on that. And right now that's to be determined. So I have this on just for a review hearing. We still, much like the other case, are waiting on DCYF records. I don't see them in the file. So I'll turn it over, I guess, to Ms. Day and Ms. Booth to see if they have anything I don't have.
I do not.
There is an order directing DCYF to submit those. They haven't been provided as of yet that I see. I will let the court know that Ms. Booth does not have any children, so that may be, but usually they would provide something that said there was no history. So
Yeah.
I will see if we can follow up on that. We have been able to effect service with father, and absent those records, I see no reason that we cannot move forward. So I don't know if you want to set this out. I think we already have a hearing set for the 28th. That might be the best thing, is see if we can't come back on the 28th and have full orders ready by then. Ms. Booth will need to prepare them if she has not already.
Okay, let me jump ahead to that date. Yep, you are right. That is on for approving the petition. So let's do this. I know with the Thanksgiving holiday coming up next week, I don't know if DCYF will respond to us in time, but let's go ahead and merge this review into that November 28th hearing. And Ms. Booth, what my hope would be at that time is that we would move forward on your request to approve the petition.
Okay.
Because I agree with Ms. Day that I think the only thing outstanding for me at this point are the DCYF records. Again, we don't anticipate, given my review of the file, that it's going to say anything, but the order that I would be signing requires me to affirmatively state that I have reviewed DCYF findings and records. So we just need them to respond and say there are no records.
I understand.
Okay. Well, and so does November 28th at 10:30 still work for you?
Yes.
Okay, we'll see you back then. Thanks for logging on. 08. It is
Okay,
set for
thank
both
you.
approving a petition and a show cause on the emergency minor guardianship. I think everyone that is online with us is on this case. Let me just double check here. I have Ms. Bliss, I have Mr. Inignasto, I have Kirsten. I have, I assume the W cost No, I can't assume that because I see Tammy Cost, you have your own video.
Yes,
Okay, and then who is under W Cost?
my husband and Sammy's grandfather.
Okay. And then I have a Miranda Smith.
I believe she's the child of Mr. Smith and the mother's partner.
Okay. And then Nicholas Smith, you're online with us, I see.
Yes, Your Honor.
Okay. Well, let me turn it over first to the two attorneys, Ms. Bliss on behalf of the minor child, and then Mr. Anagnosio on behalf of mother Kirsten. How are you asking the court to proceed today?
I was hoping we could hear from Ms. Farr. I know we set this matter over 2 weeks from our last hearing, so Ms. Farr could, I think, make contact with the parties and at least begin somewhat of an interim investigation. So I would say maybe chatting with her first. My client's obviously still wanting the minor guardianship to be approved today, so I guess dependent on where we go from there.
Okay. And then Mr. Anagnosio, what is your request of the court today?
I would agree with that. Suggestion by counsel that we hear from Ms. Farr and then go forward.
Okay. Well, Ms. Farr, we're putting you in the hot seat now. Checking in with you kind of to see where you're at on this case.
Yes, Your Honor. So I have interviewed several of the people involved in this case. I still have a couple more interviews to complete. My opinion at this point is that the child is safe and doing well in the grandmother's care, and she should remain there for the time being until the investigation is completed and the court can make a ruling.
Okay.
She's going to school. She's safe. She's well taken care of. Mother has provided me with some documentation that I haven't had time to thoroughly review yet. And I just need more time for more investigation. I have been under the weather for the last week, and so I just haven't been able to do more than I have.
Yeah, no, completely understood. It hit me last week and really threw me down. I tried to do court with no voice, all the things. So I guess let me turn it back over to the attorneys first, and then I'll come to you, Ms. Cost. It sounds to me, and I'll tell the parties, I did also receive from Mr. Anagnosio's filings, it looks like some concerns, I assume, that are going to be raised about attendance and grades of Samantha. But my thought is maybe a short set over so Ms. Farr can complete the investigation and then we can come back with a hearing. I'm assuming the parties are going to want time to prepare for that type of testimony based on whatever, Ms. Farr's ultimate recommendations will be following full investigation. But that's just my thought. I'll turn it over Mr. Anagnosio and then Ms. Bliss.
Yes, Your Honor. We're asking that this matter be dismissed. There's no additional basis from the original filing. It's basically just a rehashing of the original filing that was dismissed. For all intents and purposes, you have a nearly 18-year-old child here that's going to be 18 in February, so a couple of 3 months out. My client can't force her to come home. So this matter gets dismissed. She stays, living at grandma's house for the next 3 months, and then she's 18 and she can make her own decisions. Some of our concerns, and why we think this should be dismissed and leave basically the parental rights in my client's hands, is where she's going to school. Currently, she's going to school at Kelso. She's not doing well. That's why we submitted the grades. If the petitioner has, one of the reasons this action was brought was the petitioner asked that my client let Samantha go to R.A. Long, and my client said no, she's going to Kelso. And we suspect that if this is granted, she's going to move her to RA Long. My clients looked into it. Samantha will have to start the 12th grade over again. She would basically be going back into a junior year instead of her senior year, and then start 12th grade again in Longview School District. And it's just setting her up to fail. The petition, there are no facts stated by my client, by the mother, of any issues in her household, other than they've made vague allegations against her current boyfriend, the person she's residing with, Mr. Smith. You know, the court already dismissed it, this action based on those. You know, this is what we have. This is the real issue, Your Honor. My client took her daughter's cell phone away. Her daughter, Samantha, is doing very dangerous things with cell phones. She's in internet sites. She has supposedly an international boyfriend that she wants to go visit that, you know, would require her to leave the country. And I forget the country where this boyfriend lives, but giving her mental health issues and her struggles, this is extremely dangerous. So my client takes her cell phone away, and here we are. You know, the court needs to support parents trying to parent their children and give them the tools they need to be successful. Samantha has significant mental health issues. My client was dealing with those, and has this issue with regards to cell phone and internet abuse. My client was dealing with that from her point of view appropriately, and here we are. So we're asking that there's no new facts stated from the original petition. It's just a rehashing, that my client be supported, that this matter be dismissed. She can't physically drag her 18-year-old daughter out of her mother's house, but you know, things would just kind of stay the same. She would be residing at the grandmother's house, going to Kelso, and they would, you know, a family needs to work together to get, you know, a child over the finish line into adulthood, and that's all my client's trying to do. And she's doing a good job and needs to be supported.
Ms. Bliss.
Thank you, Your Honor. And for the record, I do represent the minor child in this action. And counsel's resuscitation of the case is interesting, and is precisely why Samantha needs protecting. Mom is constantly minimizing the exposure that this child has been exposed to domestic violence, dangers within the household, failure to protect, potential neglect. These are the reasons that this matter is before the court. Mom's position is a little interesting. She doesn't want the minor guardianship to be approved, but she also doesn't want the child home. And I think that that's very telling in her own statements that she's provided to the court. She has no faith in her ability to parent this child, at least as of right now, regardless of the reasoning. Since going into grandma's care, my client has been enrolled in counseling and is actively engaged in counseling. She is attending school. If Your Honor did look at the attendance records, yes, she has missed some school. She also has 4 active litigations happening right now. So there's a lot of court time that she's having to miss school to attend court. And I also think it's interesting looking back at Mom's declaration submitted to the court. Failing grades and failing classes is not new for Sam. Unfortunately, she struggles with some school, and Mom acknowledges that even in her own declaration. To now say that, oh, now that she's been in Ms. Cost's care, now she's having trouble in school, now she's not attending school, she's failing to see the issues here. And I definitely think that is precisely why Ms. Farr has been appointed to investigate. I think we need to allow her the opportunity to investigate, to determine what is best for Sam. As of right now, she is safe, she is happy, she is thriving. I think dismissing this action today without all of the facts would be an error.
Ms. Farr.
Your Honor, I would just add an additional comment that if the guardianship were to be dismissed, even if Sammy did stay with the grandmother wouldn't have any authority for decision making, even if it was just for the next 3 months. So it's necessary to have the emergency guardianship in place for that reason alone.
And Ms. Cost, is there anything you want to add before the court decides this motion to dismiss that's been made orally?
When Samantha came to my home, she did not have medical insurance. She was not in services for this undocumented claims of her having schizophrenia. She was in a new school, according to what Sam told me, the 5th high school since beginning 9th grade. She saw patterns of behavior in her mother's partner that were very reminiscent of prior partners that escalated to domestic violence and outright abuse. And some of those claims have been substantiated by a statement provided by her sister that has been filed with the court. I had said many, many times that if the girls were ever unsafe, they could call me. I would come get them. We wouldn't talk about it that night. It didn't matter if it was a party. It didn't matter what it was. We wouldn't talk about it that night. We would talk about it the next day. My daughter was aware of that. When Samantha called me, that's what I did. I have made efforts to talk this out, to no avail. I have returned her once after being told that grandparents have no rights to their grandchildren in the state of Washington. And within about an hour and a half, she was back in my custody per my daughter's instructions. Since then, we go through times of she can stay with us, and then I get these demanding, ranting text messages after I've gone to bed, demanding I produce the child and all of her belongings within an hour. And in the next minute, it's okay to stay with us. I've been able to secure her medical insurance. She is in counseling. She just began a medication for mental health. To the best of my knowledge, her diagnosis is not schizophrenia, and there's been no documentation provided to me stating that she has that. She is struggling in school. This has been very stressful for her. When Sammy first came to me, she wore clothing that was double the size of what she needed, and she hid in her clothing, and she would hide in the bedroom. She now wears clothing that fits. She comes out of the bedroom. She engages with us. Things are not perfect, and there's going to be struggles moving forward. She's got a lot of work to do. But for this to be dismissed, I have no reason to believe, after Kirsten's text, that as soon as this is over and Sammy returns to her house, that we will have no contact with Sammy. We will have no access to Sammy. There's been conversations about online schooling, which would remove the ability of the school staff to intervene if it went sideways. And I just don't see that, even though we're this close to Sammy being 18, that in any way protects her if her belief about the escalation of domestic violence occurs.
Okay. So here's my ruling on the
Your Honor,
motion.
can I just make a quick comment? I'm sorry.
Of course, go ahead.
My client wants to testify and respond to all those allegations. She denies those, and I'll leave it at that. I mean, that was testimonial, and she hasn't had her opportunity to have a say.
Understood. And I am not taking any of this as sworn testimony. I'm taking it as argument and giving it the due weight that it is entitled in such a situation. Here's what I'm going to do on the motion to dismiss. How I'm looking at this is from a baseline standard of, do I believe that there's enough information in the file that I would grant an immediate order, ex parte or otherwise. And what I see, so this case did go to hearing originally in September of 2023. There was testimony taken. What I think the court must always strike a balance between expediting decisions for parties, all parties, and actually determining if there is a parent able and willing to undertake parental functions. I think that, I guess my concern is there was no attorney appointed to the minor when that testimony took place. I'll also note for the record, Ms. Gilliam requested an attorney the day before or the day of that hearing and wasn't appointed an attorney, and the hearing went forward. There was no guardian ad litem to investigate the allegations or the parties. So I'm not here to say whether the first judicial officer got it right or wrong. That is not my place at all. I just think we have the appropriate safeguards in place for all parties. We have an attorney for the mother, we have an attorney for minor, we have a guardian ad litem now. I think that we are better situated to make a decision about whether there is a parent able and willing to perform parental functions. And when I look at the definition of parental functions, I think right now, just looking at what's pled in the file, which does also include statements from other children of Ms. Gilliam, I think there is a there's enough for me to make a threshold filing that this matter should not be dismissed, but should be set for a show cause after Ms. Farr completes her investigation. What I'm specifically looking at are a couple of things. Parenting functions includes those things like maintaining a stable and consistent relationship with the child, attending to their daily needs, including supervision. It includes assisting the child in developing and maintaining appropriate interpersonal relationships. It also includes exercising appropriate judgment regarding the child's welfare. So I think what I have here are allegations from the minor who is almost an adult. So I have to take that into account. This is not a 4-year-old or a 7-year-old or a 10-year-old even, who has concerns about whether her mother can give her that stable, safe, consistent environment given the mother's choices in who she brings into the home. So I'm looking at it from a lens of I'm not making a decision about whether Ms. Gilliam is able and willing to perform those parental functions. I want to set that for a show cause hearing. I'm just stating here today that I do think there is new information since the original order, I think, or decision, that there are new safeguards in place, specifically an attorney for the minor so that her voice is heard. And so I think that there's absolutely a threshold showing that the immediate order should be reissued until we come back on a show cause. So that'll be my ruling today. I would just state, I did see the filing, the concern about grades and attendance, and my hope, Ms. Cost, is that I understand the arguments of Ms. Bliss that certainly being involved in litigation and having to file for protection orders and things like that can certainly impact probably Samantha's ability to focus on schoolwork. But I am hopeful that you're able to maybe reach out to the school and get her some resources to really increase attendance, increase grades. Those are all things that the court would like to see. So I'm encouraging you to do so. I can issue a bench order if the parties want, denying the motion to dismiss the petition and setting for show cause. What would be the date the parties would want for show cause? And I might first turn to Ms. Farr, because I think the investigative piece falls on you. So I don't want to push you too far. I know you're one of 2 GALs we have on this docket, and I take that into account.
With the holidays in between, I would say at the minimum the 19th of December.
I think given the likely contentious nature that this case will take and the number of witnesses that may provide declarations or want to testify, I think setting it out that far probably makes a lot of sense so both attorneys can be prepared. Are you both available on the 19th?
That works for me.
That works for me, Your Honor.
Okay. And Ms. Cost, will that work for you?
Yes, it will.
Okay. So I am going to reissue the immediate order. Having made that finding of a threshold showing of its need just through December 19th. At 10:30, I wrote PM. Please don't log in PM. I'm going to correct that to AM. And we'll see you December 19th at 10:30 AM.
Thank you, Judge.
Thank you.
Anything else we need on this matter?
Nothing for me.
Okay.
No,
Nothing.
Your Honor.
Okay. Is there